Tim McCormack's been at Monash many times. He completed his PhD here some years ago, and last time I think he addressed the Monash audience, it was at the Caston conference, and they said that really it would only be an alien who didn't know about Tim McCormack. So we're not going to make that assumption, so I will do a brief introduction. Professor Tim McCormack is a professor of law at the University of Melbourne, and is a special advisor on international humanitarian law to the prosecutor of the International Criminal Court in The Hague. He's also an adjunct professor of law at the University of Tasmania. He's Tasmanian originally. Tim was the Foundation Australian Red Cross Professor of International Humanitarian Law and the Melbourne Law School, and also the Foundation Director of the Asia Pacific Centre for Military Law. Importantly, especially in regard to today's address, in 2011 Tim was appointed by the government of Israel as one of the 2 international observers for Phase 2 of the Turkel Commission of Inquiry. Professor McCormack has also been involved in a number of high-profile international law cases involving in particular Slobodan Milosevic, and also in regards to the Australian David Hicks. He's taught at various graduate and undergraduate courses across Australia and elsewhere, and he was also the first Australian recipient of the Golda Meir Postdoctoral Fellowship for the Hebrew University of Jerusalem in 1989, and really this list of accomplishments goes on and on and on, so I don't want to take up all the time speaking, so without further ado I'd really like to make Professor McCormack feel extremely welcome back at Monash University. Thank you for coming, sir.
Thanks very much, Anwar, for that introduction, and also for all your efforts in chasing up on the date. I appreciate that very much, and also let me thank MonJSS for the invitation to come out here. The invitations to come to Monash are pretty rare for me. I think it has to do with where I'm now based, sadly. But it is actually a nice thing to come back here. I spent 5 years of my life on this campus. It's changed a fair bit in the last 29 years since I first arrived here in February 1984. But it is good to be back and see the law school building as it was, although there's a new entrance just being constructed. 30 years ago this year, I was in Tassie. I'd finished my undergraduate degree, and I was actually, in 1983, vice principal of one of the halls of residence down there. It's a job I was offered for a year to sort of fill in for someone else who left early. And I was applying about this time, actually might have been May or June, might have been middle of the year, 1983, applying to come to either Monash or Melbourne. I applied to both places to undertake an LLM by research. I subsequently transferred my candidature from LLM to PhD. But Monash were the ones who got back to me first and offered a scholarship, and I took it up. And it was absolutely the right thing for me to do, because the person who supervised me throughout my PhD was a guy called Harry Riker, who was an adjunct professor here. Now lives in Brooklyn and teaches at the University of Pennsylvania as an adjunct professor there. He was at the bar here and also teaching at Monash International Law, and had a very large supervisory load, but took me on. And he was the best supervisor I could have had in the whole of Australia in retrospect. And I'm very grateful for the opportunities that I had to come here. It's nice to come back. I have been back a couple of times in the last 2.5 decades, but not very often. More often, in fact, to Monash's campus in the city, or to Caston Centre conferences, usually in the CBD. I want to, before I launch into talking about my involvement in the Turkel Commission, say a few things about events leading to that, because no one asked me if I perhaps try and weave in a little bit of my own story, so I'm happy to do it. I grew up in Burnie in Tasmania on the northwest coast, and moved away from home in 1978. We're talking a long time ago. This is one of the reasons why I was able to refer to such a lengthy list of accomplishments, because it helps with the passage of time. Before most of you were born, I moved away from the regional centre of Burnie to the metropolis of Hobart, and studied law in Tassie. In my final year, I did a supervised legal research subject, the supervision of a professor at the University of Tasmania who's no longer there, but now at the National University of Singapore. And my research paper was on international legal aspects of the Arab-Israeli conflict. I was very interested in the Middle East, wanted to find out a bit more about it, and I worked on that paper. And while I was doing it, I saw an advertisement in the university newspaper for an Australian Academics of Peace in the Middle East study mission to Egypt and Israel. And the advertisement said, this is, I'm talking about 1981, the advertisement said there are limited places available for senior academics and their wives. Now this is terminology that would be completely unacceptable in the 21st century for good reason, but back in the early 1980s you seemed to be able to get away with that sort of garbage. And I read that and thought, well, there's an implication there that you don't have to be a senior academic. I'm not the wife of one, by the way, but I'll write anyway and express my interest. So I wrote off to the Australian Academics for Peace in the Middle East and explained I was a final year undergraduate student and I was really interested in going on the study mission. And I was working on this research paper on international legal aspects of the conflict. I got a letter back which didn't say you got to be joking, fortunately. It said, thanks very much for your expression of interest. You have to understand that we couldn't, of course, knock back an application from a professor of Middle Eastern Studies at the University of Sydney because an undergraduate student at the University of Tasmania wanted to go on the study mission, but if we don't fill all the places, I'm not quoting verbatim, by the way, this is my sort of paraphrase. I don't think I've got the letter anymore, but if we don't fill all the places, we'll keep your application in mind. I didn't hear anything more until later in the year. I'm not exactly sure. I suspect it was October. But coming in towards the end of the academic year and the final exams, I got a phone call to say that Professor Julius Stone, then Challis Professor of International Law and Jurisprudence at the University of Sydney, was going to be in Melbourne for a one-day seminar in November on international legal aspects of the Arab-Israeli conflict. Was I interested in coming? I said, I'm very interested. I had a final exam the next morning, my first final exam the day after this seminar was scheduled back in Hobart, and I checked the flight schedules and worked out if I got the 6 a.m. flight, I'd be right. And I said, no worries, I'm coming to the seminar. Now, I think back on that and I wonder, if one of my kids was in that situation, would I advise them to do that? I probably wouldn't. I'd say, you've got to be nuts. What if the plane's cancelled? You know, I mean, all sorts of what ifs. I took the risk. I came over here. I got back in time for the exam. I did the exam. And I didn't realise, as a naive young fella from the northwest coast of Tasmania, I didn't realise that they were really, you know, testing me to see how keen is he? Is he a tosser? You know, I mean, it's like, let's see if he's fair. He comes over to the seminar, we'll check him out, and then we'll decide whether we invite him to join the study mission or not. I passed all those tests apparently, and they rang me up, and especially once they found out I had a final exam the next day, they rang me up a couple of days later out of the exam. I said, yes, it's fine, you know, no worries. We've got a place in the study mission. You're most welcome to come. Fantastic. The study mission, I discovered, was going to come back to Australia 2 weeks after our legal practice course started in Tasmania, back in the early 1980s. To be admitted to legal practice, you had to do 6 months legal practice and then 18 months articles. It was a 2-year process, had to be in that order, and if you didn't do it in that order, you didn't do it. So I went to see the directors of the legal practice course to ask permission to start 2 weeks late. And they said, no, you start on the day or you don't start. Right, no worries. I said nothing to them, but in my heart of hearts, I said you can shove your legal practice course, up the orifice that it best fits. Because there's no way I'm not going to take up this opportunity, which for me represented the opportunity of a lifetime. Now, to this day, I thank God from time to time for the narrow-mindedness and pathetic inflexibility of those people. Because had they said start late by all means, no problem, it's a great opportunity, what you're about to embark on, you go for it, and then come and join us, I would have gone back to Hobart, I would have done legal practice, I would have pursued a very, very difficult path in life. I share this story with you not because I'm bagging legal practice, not at all. In fact, my recurrent advice that people ask me is get yourself admitted to practice. You should definitely do that. But in my case, I made a choice that for me at the time was a very obvious, easy decision, but which now, as I reflect back on it, was a profoundly significant one. To follow my heart instead of my head or what anyone else might give me in terms of advice, and did what I thought I was most interested in and passionate about. And like I said, I've never regretted that decision. And if I was going to give advice to anybody in a similar position, it would always be follow your heart and try to ignore, the wise counsel or the skeptics that want to deter you from that path. So I guess I already made a decision then to pursue my academic interests rather than to be admitted to practice. So doing a higher or graduate study, a master's by thesis, which I converted to a PhD, was a fairly obvious choice for me. Applying for the postdoctoral fellowship at Hebrew University, which I did when I was here in 1987. Application went in 1988. It was awarded. I left here in November of that year and was in Jerusalem through most of calendar year 1989. Fantastic opportunity. Both of my wife and I, we'd just been married 12 months. It's been our first wedding anniversary in Jerusalem. And that was an experience that neither of us ever regretted. If somebody had said to me in Jerusalem, studying Kitta Aleph in the Ulpan at Hebrew University, that you will come back, let's have your palm read, you'll come back to Jerusalem in 2011 as a guest of the State of Israel to observe an International Commission of Inquiry, I would have choked, would have laughed, I wouldn't have believed that. So it's been a great journey for me to be able to pursue what I'm most interested in, as a consequence of that to have this opportunity presented to me by the Turkel Commission. So let me sort of use that as a segue to make a few observations about the Turkel Commission and what we're on about. Many of you will remember in May 2010 the Israeli Defence Force interdiction of the self-declared humanitarian flotilla of vessels from Turkey trying to break the naval blockade and travel to Gaza without going to the Israeli port of Ashdod to unload their humanitarian supplies, allegedly, but to run the gauntlet of the blockade and land off the beach in Gaza and send the stuff in by whatever, rubber duckies, I don't know what the plan was. There's no jetty that goes out from Gaza. You all know about the particular incidents on the Mavi Marmara, perhaps not all the fine details, but that there was an exchange of lethal force and some Israeli soldiers were wounded, a couple of them very seriously, and 9 people on board that vessel were killed. As a consequence of the incident and outrage around the international community, Israel was under a lot of pressure about agreeing to the establishment of an international commission of inquiry. And the government of Israel chose not to approve that and instead established the Turkel Commission in phase 1. Well, at the time, established the Turkel Commission. Turkel is a retired justice of the Israeli Supreme Court, Yaakov Turkel. So he's the chairman. He was the chairman of Turkel Commission phase 1 and 2, and so the Commission of Inquiry carries his name. The mandate of the Commission initially, when it was set up in following the incident, within a month or 6 weeks, was to inquire into Israel's handling of the interdiction. And that happened. A number of individuals came and appeared before the Commission and testified, and the Commission wrote its report and tabled that in February, might have been March 2011. And once the report was tabled, the government of Israel decided to extend the mandate of the Commission into a second phase. Throughout phase 1, from whatever it was, April or May 2010 through to the tabling of the report in February 2011, March 2011, got the dates a bit confused. I wasn't involved personally, so I'm not quite accurate on the months. But after the tabling of the report of phase 1, the government decided to extend this mandate beyond looking at the Mavi-Marmara incident, but to look more generally at how Israel investigates alleged violations of international humanitarian law, alleged war crimes, either by the Israeli Defence Forces, by the Israeli police, or even by Shin Bet, especially in the context of their interrogations of people under their custody. Throughout phase 1, the government of Israel had appointed 2 international observers. This decision, this policy decision, was taken as a way of trying to placate some of the criticisms of Israel undertaking its own national investigation in favour of an international one. And those 2 observers were Lord David Trimble, the former First Minister of Northern Ireland, former Nobel Peace Laureate, in fact, for his role in helping end the Northern Ireland conflict. And the second international observer was a Canadian Judge Advocate General, Brigadier, now retired from the Canadian Armed Forces, but previously their most senior uniform legal officer, Brigadier Ken Watkin. He was the subject matter expert on international humanitarian law. But at the end of phase 1, Brigadier Watkin had to go back to North America. In fact, he had a position in the US at the US Naval War College as visiting professor of international law, and he had to go and take up that position. It sort of delayed it as long as he possibly could, but it was untenable to not go and fulfil the position, or fill the position. So the State of Israel was looking for a replacement for Brigadier Watkin, subject matter expert in international humanitarian law, and that's where I came into the mix. I think there were a number of names that were floated as possibilities. I had my interview. It's not a job I applied for, but I had my interview in Sydney in May 2011. I was up there for, some of you might remember, 2 Australian soldiers were charged with offences by the Director of Military Prosecutions to appear before a military court-martial in relation to an incident in Afghanistan. And I was working with the defence team on that case. And the preliminary hearings were in Sydney in May 2011, and I got a phone call from the Executive Officer of the Turkel Commission saying, "Where will you be this week of May the 20th? I said, "I'll be in Sydney." He said, "Will you be free?" I said, "Not during the day, because I'll be in Court-Martial. You can come and sit in the public gallery with me if you wish, but that's where I'll be." "What about the evenings?" I said, "More than happy to spend a couple of evenings together," which is what we did. As a consequence of all of that, I was invited formally to replace Ken Watkin, and it was a great experience for me. I went 5 times between May 2011 and February this year to meetings of the Commission, where we were working on the draft of our report and the framing of our recommendations to the government. And in February this year, we tabled our report to the Prime Minister in his offices in Jerusalem. Prime Minister of Israel, I'm talking about, not Julia. Bibi, Prime Minister Netanyahu. I really enjoyed the work on this Commission inquiry. We weren't looking at specific alleged incidents, we were looking at policy and structure and processes. And one of the reasons I found it fascinating work was because in my study of international humanitarian law, now for more than 20 years, I had tended in the past, prior to this experience, to focus on 2 things: to focus on the substantive rules and to focus on prosecution for alleged violation of those rules. And there is a fundamentally important step in between those 2 things, and that is investigation of alleged violations of rules. I tend to think about, here's the rules, and someone's violated them, you've got to get that person on trial. Yeah, okay, but in between, somebody has to take responsibility to investigate the allegations and work out whether there is a case or not to be brought against one or other or more individuals, and then to initiate proceedings. And this study that we undertook in the context of the Turkel Commission was all about that issue. What are the international legal obligations in respect of investigations? What has to be investigated? Who has to take responsibility for investigation? What constitutes an effective and impartial investigation, an independent and impartial investigation? And then how does that framework of legal obligation stack up when you evaluate the Israeli process or processes and structures? To what extent are they consistent or not with those international legal obligations? So we made 18 recommendations. Some of them are structural ones that identify weaknesses in the processes that Israel has, and some of them are more substantive that call for reform of the Israeli legal system. Perhaps I can just give you a couple of examples, one each from what I'm talking about. In relation to substantive recommendations, our first recommendation is that Israel undertakes legislative reform to ensure that all the war crimes in the Rome Statute for the International Criminal Court are explicitly part of Israeli domestic criminal law. They are not at the moment. And one of our suggestions is that they should be. The argument, of course, against that is, look, you know, it doesn't matter what label you attach to the alleged offence, as long as you've got a rule that, or a norm that prohibits it. So we all have in our domestic legal systems the crime of murder. Why do you need the war crime of murder as an alternative charge? I mean, that's sort of an example, not the only one, but there are others as well. So the argument by those opposed to our recommendation will be that Israel's domestic criminal law covers the field in terms of the substantive international criminal law, the war crimes offences in the Rome Statute. Our argument is yes, but sometimes you need a specific label to attach to a specific offence, and you ought to think about doing that. Perhaps more importantly, on the substantive recommendations, we've recommended that Israel explicitly provide for criminal responsibility for military commanders who fail to exercise their authority to stop atrocities being committed by those subordinate to them. This is a fundamental rule of criminal accountability in international law. It's in the Rome Statute as a specific provision, Article 28, and in Israeli domestic criminal law it is not provided for. In Australian domestic criminal law generally, it also was not provided for until Australia ratified the Rome Statute for the International Criminal Court, and then in our implementing legislation we added that in our Commonwealth Criminal Code Act of 1995. On structural things, one example of a recommendation that we made, in the Israeli military system, the Military Advocate General wears two hats. I'm a Tasmanian, so it comes naturally to me. But in the Turkel Commission discussions about the two-hatted role of the MAG, the Military Advocate General, we thought it creates a bit of a problem. The MAG, on one hand, is the primary source of legal advice for the Israeli Defence Force about operational law. And he advises the Chief of Staff, he advises the senior operational commanders about what is lawful and what is not. But at the same time, the MAG also is the one responsible for determining whether or not charges should be laid against a member of the IDF for alleged violation of the law. Now that, in our view, creates a bit of a potential conflict of interest, to be responsible for giving legal advice and then to decide who's actually may have been responsible for violating it. So we argue that those two functions should be separated out. The MAG should be more accountable to the Attorney General, and the responsibility for laying charges should be given to a military prosecutor independent of the Attorney General. So that's what I mean by structural recommendations. There are a number of others, and I'm happy to talk about other recommendations that we've made. We met with Prime Minister Netanyahu, and I'm conscious of time, so I won't run on too much more. A couple more minutes. And we presented our report to him. We met with him and discussed the contents of our recommendations. And he assured all of us that once his then pressing preoccupations with trying to form a new cabinet were resolved, he would set up within his government a committee not inquiry, a committee to examine our recommendations and to work out how best to implement them. So we're waiting for feedback about that process, and I'm, as you can imagine, watching it with very keen interest. In the end, a commission of inquiry doesn't have the authority to make the changes itself. All it can do is make recommendations, and it's up to the government that receives the report. That's the same in our system. Here in Australia, the government that receives the report to decide how we're going to take these on board and deal with it. For me, it was a terrific thing to be able to go over there multiple times, to be still able to read street signs in Hebrew. I was really encouraged by that. Hadn't lost my vocabulary entirely. The biggest tragedy for me that is in the YouTube clip where we present the report to the Prime Minister. My maybe pathetic attempt at engaging Bevrit is just cut out, excised from the YouTube clip on the state of mind. He even said, not bad, not bad. And then asked me where I learned to speak that way. It's worth telling you. Look, I'm happy. I want to open up for questions and discussion. I'd rather hear from you about what you're interested in. I'm really happy to talk about work at the Hague. I'm happy to talk about being involved in the hospice trial or David Hicks, whatever. I don't mind. I just don't want to keep raking on and deprive you of the opportunity of saying what I'd really like to ask about is this. So,
in light of the flotilla...
Let's start over here. What'd you tell me you were? Vice President.
In light of the flotilla, a lot of restrictions on Gaza were eased. So, although the flotilla, was not necessarily legal anymore, and there was a lot of problems associated with it, it was successful in the long run, and the restrictions on Gaza were lifted. I was wondering if you could just comment on that
Sure.
aspect.
I think I've never spoken to any of the people involved in the flotilla. I don't know how they would assess the success or otherwise of their operation, but there is no question that they raised the international profile of the Gaza situation, of Israel's approach to the blockade and the naval blockade, as well as its control of the territorial borders, and probably, I suspect it would be fair to say, generated a fair bit of international sympathy for the Palestinians in Gaza. So there would certainly be one level, not so much the legal level, but in terms of public awareness raising, that people involved in organising the flotilla would say it's been a success. We never got the ships to Gaza, but like I suggested before, I'm not really sure they would have done if they had, because it would not be an easy thing to unload vessels without some sort of jetty or port facility. So I don't think that was the intention ever. The intention was to see how far we would get, and as a consequence of however far we get, the international media attention that's what it be.
I was just wondering whether I could get your thoughts on what Amnesty International said about the Turkel Commission. I just looked at their website and they said they condemned the conclusions of the Turkel Commission. They said that it was that you hadn't interviewed any people who had been on the boats. I don't know the specifics, but they basically said you'd got it wrong. So I wanted to know whether you'd seen that and what you thought.
Yeah, look, I'm happy to share my thoughts about that. In terms of the report of Phase 1, which is what we're talking about.
They weren't talking about your one, were they?
They were talking about ours as well.
Okay.
No, they weren't.
I don't know.
Because these criticisms about not talking to anyone on the vessels are not relevant to the report of Phase 2 because we weren't talking about the flotilla. So let me deal with the two reports separately in terms of international reaction. In relation to the report of the Turkel Commission from Phase 1, there has been a lot of criticism of it because, first of all, it's an Israeli government commission inquiry, and there are some people and some organisations who won't accept it because of that. It doesn't matter how rigorous the process has been, how how well argued the assessment is of the legal situation in Gaza, the entitlement to exercise a naval blockade, the entitlement as a consequence of the existence of a naval blockade to interdict ships trying to run it. So that I think is important to identify. There are others who are more open-minded, who have read that report and have been very positive in their analysis of it. And I guess the most important of those groups has been the UN-established Palmer Commission of Inquiry, which is named after Geoffrey Palmer, the former Prime Minister of New Zealand, who is a practicing lawyer in Wellington, but has a high international profile as a consequence of his political office previously. The Palmer Commission of Inquiry accepted the legality of the blockade and said that Israel is entitled to defend itself from and to ensure that ships carrying whatever, carrying cargo not identified and not scrutinised by Israel can be stopped. And the Israelis are entitled to ensure that they know what's actually being carried. And if it is for humanitarian reasons, then it should be allowed to then pass into Gaza, which is, I mean, entirely consistent with the Israeli government official position. The Palmer Commission inquiry was critical about the amount of force that was used by the IDF on the Mavi Marmara, but not of the legality of the operation itself. Well, that was, as far as the Turkel Commission itself was concerned, and I think the government of Israel, high praise indeed, that a UN-established organisation, commission of inquiry, would reach a conclusion like that. The Turks were furious about it and outraged that the Palmer Commission of Inquiry would come out with a finding that the blockade itself was legal, and tried to make their own, cast their own aspersions on the objectivity of the Palmer Commission findings. So yeah, look, I mean, the reaction has probably been mixed in relation to the report of the first phase. I knew that when I was asked to join phase 2, and when it was announced publicly that I'd agreed to, some of my colleagues said, "You're brave," and I said, "You mean you think I'm nuts?" No, I didn't say that. You're brave. And I said, well, I just reckon that this is an important thing to agree to do. And in fact, I had a very detailed conversation with the prosecutor of the International Criminal Court for asking whether he was happy for me to do this or not. Because, I'd already been his special advisor for a year and a half when I joined the commission. I thought I should discuss it with him. There are potentially political ramifications from joining an Israeli government commission inquiry. One of those, for example, is that I couldn't go to Gaza on my trip in February because I'm an increased abduction risk by the Salafists in Gaza. If I went to Gaza, it will be with the approval of Hamas. You can't go to Gaza otherwise. But it's not enough that Hamas approves your entry into Gaza to guarantee that you'll be safe. Okay, I accept that. When I first took this position on, I understood that there might be implications at work. But the prosecutor's view was that any country, state party to the Rome Statute or not, that wants to take seriously improving its own internal structures and processes and mechanisms for investigating international crimes must be encouraged to do so by the court as an institution, by people who care about international criminal law. So you should go for that. If you want to do it, you go for it with my blessing. And if the Palestinians are upset about it, I'll handle that if I need to. Good on him. I mean, I really appreciated that. And it was really on the basis of his encouragement that I felt emboldened to do it, and I have no regrets. The second report, the report of phase 2, I think has been much more warmly received by the international law community and the international community more generally, because people who have an objective approach understand that the work that we've done, especially in our first substantive chapter on the international legal obligations in relation to investigation, is serious work. And of course, there will still be people who have a particular position that it's an Israeli government commission inquiry. That's it. I mean, I'm not prepared to take it seriously. Okay, fair enough. I mean, I'm not going to be able to change those sorts of attitudes. But I don't think that is the prevailing view. And maybe that I can say that because phase 2, the report from phase 2 does not look at specific incidents. Maybe it'd be more controversial if we did. But and I think it's been a very difficult thing to have looked at specific incidents. We're trying to take a holistic view of the way that it happens. And yeah, if our 18 recommendations are all implemented properly, I'm very confident that there will be some incremental improvements in the system that's been operating now for many decades. Yeah.
I've just got a bit more of a general question. With regards to the ICC, there are lots of countries that have recognised it, there are lots that haven't. If you look at what the political situation is in the Middle East, you know, Hamas, a terrorist organisation, isn't recognised politically by lots of other countries around the world, just as there are lots of other countries that don't recognise Israel. How can a authoritative international committee come to conclusions and recommendations based on parties that are involved but don't recognise each other and don't recognise the validity of each other's arguments in a legal context? Because so how can a decision be reached and is agreed upon by the people involved when they either do or do not recognise anything that's been happening?
Yeah. You're talking about a decision by the International Criminal Court?
Yeah, in general, just how lots of people are saying how, you know, there have been activists saying, oh, the Israeli soldiers should be taken to the ICC like war crimes charges. People are saying the terrorists in Gaza should be taken on war crimes charges, and yet at the same time, there are so many parties involved that don't recognise this party and don't recognise the ICC. How can all this work?
Yeah. Well, it's working at the moment, of course, selectively, because the International Criminal Court has some major limitations to its exercise of jurisdiction. It doesn't have jurisdiction over every conflict situation in the world. If it did, then there should be formal investigations of what's happening in Syria right now. There should have been formal investigations of what happened in Sri Lanka in the last months of the civil conflict there. There should be investigations of what's been going on in Zimbabwe for decades. I mean, you could just go on and on and on. So we, as an institution, the International Criminal Court has some major limitations. But that doesn't mean it has no jurisdiction whatsoever, and it has jurisdiction in relation to the physical territory of those countries which are a party to the Rome Statute. And it also has jurisdiction over those situations referred to it by the UN Security Council. So there are 8 country situations currently under investigation or trial, and 6 of those involve states parties, and 2 of them involve referrals from the UN Security Council of non-states parties. Those 2 are Sudan in relation to the Darfurian conflict, and Libya. Now, I mean, we can talk for ages about how frustrating it is that the UN Security Council doesn't take its decisions on the basis of principle, but on the basis of politics. And there is no other way to explain the referral, the very quick referral of the Libyan situation to the ICC in February 2012, and the complete non-action by the UN Security Council on Syria. US, now that there is confirmation of chemical weapons having been used, I'm sure the US will be very happy to refer the Syrian situation to the ICC, but the Russians have said there's no way that's going to happen. We'll veto it. So we've got some frustrations about, at the moment, the lack of a systematic, comprehensive, impartial system of global justice. I accept that. Some people would say then, why bother working for an institution which is flawed? And my reaction to that is that's not the only response. That's one response, and I accept that as an entirely valid response. And you know, I have disagreements with people for whom that is their position. I accept the position. It's a valid position. It's not mine. My position is that the International Criminal Court is a major advance over what we didn't have prior to it as an international community. And I believe in the institution and what it's trying to do as a consequence of that. But I also accept that it's not a perfect system of justice, and if I'm committed to the goal of global justice, then I have to accept the weaknesses in the system and do whatever I can and encourage other people to do whatever they can to redress those weaknesses. So, yeah, we've got 8 country situations, all in Africa. That's not good enough. It's not a court set up just for the African continent. There are some good, explicable reasons why the first 8 country situations have all emanated from that continent, but in the end, that's not enough. If that's all the court does is focus on African conflicts, it will be a failure of an international criminal court. I don't think it will. I mean, there are a number of other country situations that we're looking at beyond the prosecution, but outside of Africa. But yeah, we haven't yet been authorised to undertake any form of investigations into any of them.
Just on that, I wanted to get you to elaborate a little bit more, because given the political, the political limitations, the jurisdictional limitations, the fact that when you said you believe in the institution, then certain people, there are bodies that actually don't believe that the ICC is the correct institution for it. What do you think about the longevity of the ICC and its legitimacy, and do you think that maybe just, because I know it's relatively new, it's sort of 10 or 15 years old, do you think that maybe something else will have to supersede it, or do you actually believe in it?
Yeah, that's a good question. The court is 10 years old this year. It's different dates, of course. It was open for signature in 1998, so it's 15 years since it was open for signature. The statute entered into force in July 2002, so it's 11 years since entry into force. But the first judges and the initial prosecutor were sworn in March 2003. So, we've just really marked 10 years of the existence of the institution. In that time, there's been one trial concluded. That is not a good run rate. And I'll include myself, I'm part of the institution. We need to lift our game on that. It's a very good question. What are the prospects for the longevity of the court? Double figures is good achievement. And in that time, interestingly, the Rome Statute entered into force with 60 ratifications. We're now up to 121 states parties. So there's been a doubling of participation in the 10 years since the court was established. That's encouraging. And now the institution's 8 short. I think 129 is the magic number. 8 short of 2/3 of the states, the independent sovereign nation states of the world, states parties. That will be a significant milestone when it's achieved. In terms of the longevity, I think that it'll be interesting to see what happens. When there's a first really controversial case, will probably have profound implications for the prospects for the court. Whether the international community or some key players in the international community are so pissed off by that they decide they will go for destruction of the court, or whether countries will say, great, this truly is an independent prosecutor, an independent institution, is prepared to take on some of the big players, then I'm going to support it. I don't know. I think it's a big challenge. Yeah. And I do believe very strongly that if the institution makes its decisions on the basis of political pressure, it's stuffed. Its long-term prospects cannot be good. And that might not mean that if it takes its decisions on the basis of principle, its long-term prospects are assured. But there's a better chance of it. It's tough.
I just thought it was interesting when you said believe, because I think unlike the domestic system, I think there's a lot of belief about it as well. The legitimacy is not there yet, but it's only 10 years old, so not everybody recognises it.
It's not there. It's not there yet. No, it isn't. But there's a lot of people working very hard to try and get it there. And I'm more than happy to nail my colours to that mast and say I'll try and support that endeavour.
Yeah, no, and I feel that I support it as well. I just think it's almost like a belief thing at this point because
Sure, there are skeptics here.
Yeah.
That's okay. I'm on that. Any other? No.
Yeah, it seems a lot of these issues which the ICC International Ombudsman they look to be emotionally charged. So I'm just wondering how you maintain a pretty, I don't say cold, but legalistic and detached approach to such that you don't let that get in the way of all of your analysis, investigation of the law.
Yeah. Well, I think it's a good question. I don't know if you all heard it up the back. Yeah? Yeah? Good. I guess the answer from my personal perspective is that it's really important that those of us involved in making decisions, making judgment calls, giving advice, understand that it's really important that we separate, or try to separate as much as we possibly can, our analysis of the legal issues applied to the facts and what we think the implications might be, the political implications that flow on from a decision, that there is a prima facie case that should be dealt with by the judges. Those pressures exist for all public prosecutors in our system, in any domestic criminal system already. It's just, perhaps some people say there's less at stake. There are pressures on, of course. And I think those of us committed to the concept of the rule of law want independent prosecutors who will take tough decisions about the fact that there might be some very serious political fallout from this, but my task is to act on the evidence that's been presented to me. Now, in the ICC context, the most controversial decision by the prosecutor so far has been the decision to go to the pre-trial chamber of 3 judges, and get them to approve the issuance of an arrest warrant against President Omar al-Bashir of Sudan. Sudan is a non-state party to the Rome Statute. Sudan or the Darfur situation was referred to the ICC in 2005 by the UN Security Council. And on the basis of that referral, the prosecutor undertook the investigation, decided that what was happening in Darfur, principally by the Janjaweed Arab militia groups, was in fact being done with the support of the Sudanese military. And on the basis of that finding, he went to the pre-trial chamber and said, I want an arrest warrant against Omar al-Bashir. I want it against him, I want it against his former Secretary of State, Mohammed Maroon. I want it against the guy who is the head of the Janjaweed militia, and more recently another former minister at the time has also been added to the list. The pre-trial chamber agreed. Now, Ocampo, then the prosecutor from Argentina originally, he copped an absolute hammering for that decision. What? Are you nuts? Even people in the UN said this. We're trying to negotiate a peaceful resolution to a conflict in the south of Sudan, and you go and stuff it up by threatening to prosecute the president, who is a key party to those peace negotiations. Are you crazy? Have you got no idea? What is your story, mate? And Ocampo, in the end, gave a press conference and said, look, I'm a prosecutor of international criminal law. My job is to act on the evidence that I have. The evidence that I've seen tells me this guy is one of the most responsible people for what's going on in Darfur. I am not prepared to ignore that. There may well be political implications that flow from the decision to go after him, but that is not my responsibility. That's the responsibility of the UN Security Council. The UN Security Council is the body authorised to maintain or restore international peace and security. They're the ones who have to weigh up geopolitical advantages and disadvantages with a certain course of behaviour. And under the Rome Statute, Article 16, the UN Security Council has the authority to intervene to suspend proceedings at the ICC for 12 months, and that suspension is renewable every year after that. So Ocampo said publicly, if the Security Council doesn't like what I'm doing, because it's interferes with what they're trying to achieve in South Sudan, use Article 16. The Security Council never did that. I think that's the right separation of powers. I think the prosecutor has to act on the basis of the evidence that he or she, now it's Mrs. Bensouda, is now prosecutor, taken over from Ocampo. She has to act on the basis of the evidence she has, and she has to let others, people and other institutions, worry about the potential political fallout. I hope that she's up for that.
On that courageous note, I'm not an alcoholic. I'd like to present Professor Tim McCormack. small token of appreciation
Can I
for coming
look now,
back
Ben?
to Monash.
Yeah, you can pop the
I
cork.
don't know if it's kosher, but at least it's tasty. So, thank you once again.
Thanks very much, mate. I appreciate it. Thanks for coming
Ah,
today.
quite- yeah,
And look, I mean, there are advantages in being non-Jewish, aren't there?
Thank you once again.